John, can you hear us?
I hear you.
Okay, I sent you a text with some new information.
Okay.
This was 30, it's now 1. So it has to be 102. This building. This one.
I know.
You know.
Any more?
Yeah.
Yeah, he showed.
Okay. 102 feet. That's on this one. Here.
20 feet, not 30 feet.
It was 20 feet, now
Oh,
it's
oh.
now it's 30. This was 20 to 102, because the property lines were this. This was 63, it's now 30. It is 20 feet. This was 20, it's now 27. This was 30, it is now 21. This is the only one that's gone down, these are all, this is the buildings. I didn't have the distance. We cut all the trees, so. Oh, yeah.
It's that time. Where's the?
That kind?
Okay, it's 6:30. I'll call the meeting to order. Two items on the agenda tonight. First, we have the public hearing for the Cushing storage application. And before this meeting, there was a site visit that some of you attended. I was not there, but we'll talk about a summary of that. And then open the hearing. And the second item on the agenda is the Manitoba subdivision, and we'll be taking that up following the Cushing hearing. So in terms of the Cushing application, I'm not sure who was able to attend the site visit and who wasn't besides me, but it would probably be helpful just to get a summary of the site visit and what was seen and discussed at that point. If you want to do that, Jenna?
Right. So the site is developed behind the existing storage building. And it's basically a cleared site. And John revised his site plan a little bit to move the buildings a little further away from the sidelines. And the property surrounding his property is all wooded. Always the issue later, but so it's, and John has to bring in a lot of fill because the ground is pretty wet. There's so into the water runoff that goes to the middle of the property that is gonna, yes, divert them.
Yeah, it's on the plan, just on a little catch basin. Well, it's an open catch, not really a catch basin, it's more like a pool. And then it goes to a culvert and goes down the spillway.
So it's a pretty open site. You know, except for the surrounding, I mean, it's forested all around it. most of all the trees on John's property, most of the trees on John's property have been cut down.
Most of them have been cut down except for about 20 feet on the left-hand side. On the back is 60. Anywhere from 40 to 60 feet. On the right-hand side, up close to the building that I have now, there's a few trees, but at the probably 60 feet of that 100 feet, there's only 2 trees on my property.
Could I interrupt you for just a second?
Sure.
I will open the public hearing at this point, because I think we're getting some information in that may not be in the record yet, rather than just the site visit summary. So the hearing is open at this point, and if there are other points you want to raise about the site visit, please continue.
No, that's it.
Well, the measure, I was there also, Virtual with Jack, and with Brandon, and who else? I'm sorry. Measurements, the applicant was taking certain measurements while we were there. And as a result of those measurements, there's been a slight adjustment in the plan as, and the map as has been distributed.
And I will ask John to just summarize those again for the hearing record. So anything else about the site visit that we should put out on the table now? Is that it? Okay. As a starting point, John, if you could, I think everyone is generally familiar with what the proposal is and so forth, but if you could just, really quickly summarize that again. And then if you could, for the group, point out what the changes are that you've made to the distances on the map and so forth. And perhaps talk a bit further about the wet area that you plan to divert that Jack had mentioned previously. That would be helpful to us.
Okay. Well, my plan or proposal is to build 2 buildings. One that is 100 by 50 and one that is 100 by 20. They're both storage units. That's just about it. The 100 by 20 building has doors on both sides of it. It's on the right-hand side of the map if you're looking at it. The building that is 100 by 50 has 1 door on it, which is facing the parking lot. The water, as you can see, in between the 2 buildings, used to be 63 feet. We changed the front of it to 30 feet and the back of it to 20 feet. But the water issue that you're talking about is gonna go between the 2 buildings. I'm just gonna call it a catch pond. It'll be in between the parking turnaround and the 2 buildings, right at the bottom of the turnaround. And it's gonna have culverts that bring it all the way down to a catch basin, and there's a circle on the back of that map that says basin on it. The changes, the 100 by 20 building, the closest right-hand corner was 20 feet. It's now 102 feet from the property line. The rear measurement from that building to the property line was 20 feet. It has now been changed to 30 feet. The building on the left, which is a 50 by 100, was 30 feet on the front left corner to the property line. It is now 21 feet. The back left-hand corner of that building was 20 feet. It is now 27 feet. Those are the changes that I made.
And
Or I really
John,
had-
those changes were made in response to concerns about the proximity to adjacent properties, or the.
They were made because when I measured, I half measured this because there was so many trees and there was so much stuff, I couldn't get a true reading. And when I came down with this plan, I had said that I would move these buildings wherever I had to make them comply. And the way that the property lines are, it gets very tight at the end, so we move the building so I would get the most room and the most use out of the land and have plenty of buffer on the outside. So that's why we moved them around.
So when I saw the new numbers, my assumption generally was that you know, you were looking to create more space on the right-hand side. I mean, more buffer area, so it went from 20 to 30 feet. On the other side, it was reduced. It was,
Well, it was increased on the back end, but reduced on
Yeah.
the front.
and that responds to, the proximity of residences or
You mean why
visual
did,
line of sight or,
you mean why did it get closer?
yeah,
Well, when you square the building up, it doesn't fit right. It doesn't, it's not parallel with the property or the other buildings. It's got a weird angle to it, and you have to drive around these two buildings, so if they're not somewhat square to each other, someone's gonna back into them. It makes it very awkward to build it that way and to look at it that way when you go down there and, once it's all built.
Yeah, anything else about the plan, John, you'd like to discuss?
Nothing that I have, unless you need to know something, just throw me a question.
So planning board members, questions for John?
So, so given the amount of water that's flowing through, and you've got the basin at the bottom, at the top of this plan, but at the bottom of the site, it strikes me that could end up being a wet pond there, with just cold water.
It will have water in it, but the parking lot from the other meetings and what have I approached you with, there's not gonna be another one of those in between the two buildings in the turnaround. And half of that parking lot will be tapered so the water comes towards that first one. These are made, they'll be made so I can dig them out, if they have, get full of gravel, whatnot. That water slows right down when the summer comes, but we've had some seriously wet winters, so it's running pretty good. But last summer, it was drier than it is now. The summer before that, it was pretty dry. You could walk right out there anyway. So.
So John, on this
all
map,
depends.
where is that other?
Yes, I'm gonna actually on that. You see there, it says retaining area? Right up against the parking turnaround.
Oh, yes, yeah,
Yeah,
okay.
it's gonna go right at the bottom of that retaining area.
In the area between the buildings and between that pond basin, whatever, there's two water features basically you've got there. And in between, are you running culverts down the middle?
Yeah.
That's-
Yeah, 19-inch culvert.
So the water will come down and be directed into the culvert and go out back.
It'll be actually directed, some of the water comes up on the right-hand side of that little makeshift driveway I have drawn in there. And there's a culvert in there now. That water will go to that pond that's at the bottom of the parking turnaround. And half of the water between the buildings will also go to that first pond. This way it's going to the first pond. Most of the water is going to the first pond before it gets to the second one. It alleviates, if you put it to the second one, you have a massive rain and it fills the whole pond up and then it starts spilling over, then I have issues. So if it comes to the first one, it goes underground to the second one, and then half the parking lot goes to the second one. It gives me more time if there's an issue. I don't see any issues, but that's why I designed it that way. Before it's done, I'd like to pave this, but money doesn't grow on trees, so we'll see if we can get the buildings up first. Because once it's paved and everything's green and riprap around it, there's really no sediment to put into it. The only thing that's gonna get into those ponds is from the driveway surface itself.
Other questions for John, anyone?
Is the height of the 100 by 50 building, you said there was only now one door at the end? Is that building taller? Just remind me, I can't remember.
That building, yes, is 20 feet tall. The other building is only, at the peak, it'll be, what is it, Be 14.8, something like that, at the peak.
So the concept of the 50 by 100 is more like a,
It's like Roberts,
yeah, like
it's
a,
just like Roberts, it's a commercial style building.
Yep.
One door.
Yeah.
Yeah,
because there's not a lot of lot space on the side there, so.
no, there's no really room for doors without. No, and that's why I put that building on that side.
So the buildings are not all the same height. That one you just mentioned is 20 feet, and can you remind us of the height of the others?
The height of the first building is, what size is that? Only 10 by 20 units, but that building is 109 feet long. That building is that building I think is, I believe, I'm just going on recollection, 16 feet tall.
16.
The one that you can hardly see. And the other buildings will be roughly 3 feet lower than the parking lot in front of that building.
Yeah.
And that building is a foot lower than the parking lot.
Yeah.
So you're talking, do my math here, 3, 4. You're gonna be roughly 4 feet lower, but you're 4 or 5 feet taller, so it's about the same height. Overall, the land is different height, but the building is almost the same height if you were to put a level across them.
And
Go ahead.
I was just gonna say, and no changes to like lighting or anything like that? No. The previous, okay.
I don't have your application here, but I don't remember the height of the building being 20 feet, I thought both of them were 10 feet. Or something. I just wanna make sure you have the right height.
I have it right. It was, when it was sent in, I think it was wrong, because I noticed that, at the meeting before last, I'm like, that building's not 10 feet tall. You know, this is a commercial building, it's 20 feet. Wall height,
So,
sorry.
So John, the plan that you had in
Mhm.
with your application didn't have this 20-foot height, didn't have the correct height?
It did not, it had a 10-foot height, but it was an oversight, I don't, because I had Christine do a lot of this, and I'm not blaming her on it, because I was the one that looked at it, and I didn't see it. But I saw it a couple weeks ago, I'm like, what is that? That is not the right height. So,
so the building that's 20 by 100 is 10 feet, and the building that's 50 by 100 is 20 feet.
yeah, wall height, right. When you have those two buildings done, you won't be able to see them over the building that's there now.
I think, John, just so you know, we need to be sure that the documentation for all this reflects, what you're
Exactly
actually
what it is.
going to build.
Yes.
And so we'll have to address that in some way to make sure it gets into the record.
Yeah.
Did you have something else?
Yeah.
You did, you had trees. I don't want it to come up later, so I might as well take care of it now. On the right-hand side, on the back, I don't have a lot of trees on the property, but like I said, I can plant trees.
Well, I wasn't, I didn't think you needed to plant trees unless something happened where the butter said, I can see his warehouse and he needs to plant trees because I shouldn't have to maintain trees to,
She'll have to walk up to the line.
so we'll have.
She's got so many trees between her and that.
I don't see it happening,
Yeah.
but some condition where if it came to happen, that you'd be responsible for.
Yeah.
The buffer
Yeah,
at some point, maybe.
I don't mind if it's in there, it doesn't take anything to plant a few trees.
Other questions or issues for John? Okay, so I'd ask if, I don't know if there is anyone, either in attendance or, in the Zoom space who has comments or questions, but I'd invite you to participate now if you do. Ms. Wright, I know that you had an interest in this project. Did you have comments or questions?
I do have interest and I was late to coming, as I was involved with a board meeting with an organization, but I did get the tail end of, the comment about trees, and I think that, I, we have plenty of trees between us and next door, and, we're pretty familiar with what's out there coming and going. So for now, you know, it doesn't cause us an issue necessarily. And who knows how it'll go as things go up, but we're always interested to watch. And thank you.
Can I mention something? If you, we've had one neighbor that has had, an issue with someone that showed up there. If you have an issue, if you see something, I would love a phone call as soon as it happens. Because if you wait a month or 2 months, it's hard for me to, I have cameras in the first building. And I think they last 10 to 12 days, the photographs that it takes. But if I don't know there's something going on, I can't, you know, once it's erased from the camera, I can't see who's going on. I am around there a lot. I pull in there in the middle of the night, but, you know, to be there exactly when someone else is there causing havoc is pretty hard to do.
So you're asking that, us as a butters, if we see something that doesn't seem quite right back in that space, to reach out to you?
Yeah. you're right on.
Certainly would. And you've got a public phone number for us to call if that's the case?
Yeah.
I-
Public phone numbers.
Okay, I know I've done the same sort of thing with Camp KV. We have permission to wander their space, and we've come across stuff on occasion and just reached out to their director, and they've been really appreciative of that. So looking out for each other is really important, I think, and certainly we'll share if we see anything out of sorts.
Thank you.
Hey, thanks very much. Is there anyone else who has comments or questions on the Cushing application, either in the Zoom space or in the room? If not, I would ask for a motion to close the hearing.
I move to close the hearing.
Second.
Motion, second, discussion. All those in favor? John?
Aye.
It'll come back on, it's just the projector. It does that.
Yeah, if you're ready to make a motion, please go ahead.
I'll make a motion to approve the application as amended to include one building that's approximately 50 by 100 by 20 feet tall, and the other building 20 by 100, 10 feet tall, and situated on the property no closer to the property lines than is depicted on the map. The site plan that was revised on May 14th, 2024. And with the conditional, standard conditions of approval, and that, that the owner is responsible for maintaining a natural screening or buffer to shield the building from public view. But I'm not requiring, I'm not saying that there has to be any planting now, it's just his responsibility if it ever becomes an issue.
There's a second.
I'll second it.
You've got a motion and a second, discussion.
Paul, you raised the question about having a final plan that depicts the buildings, the dimensions.
Yeah, yeah, the dimensions will be reflected in the conditions, but yeah, it would be helpful for the plan that's actually in the file of the project to have the correct dimensions on them. And, you know, perhaps that's, I forget what the original plan looked like, but maybe it's a revised plan that reflects the building dimensions as well as the measurements from the property boundaries and so forth. So we finished revised final then.
As long as that's turned in before the application or before the permits, you know, so how do I go about just turn it in and that's,
Yeah, I think that you can just submit that, you know, as soon as you can.
yeah,
And, it can be entered into the file as a substitute for the pieces that are in there that no longer reflect the correct dimensions and measurements.
Make sure you include the height on
I will definitely do that.
Paula?
John,
Thanks. I assume that, at some point in the future, if, John decides to pave the drive, that we'll be able to, have a look at issues connected with that.
Don, do you think that that would have a significant impact on the, you know, the site water management, given what he's proposing?
Not given what's proposed, I mean, the fill is largely impervious once it's compacted anyways.
Yeah,
It's not gonna really change anything. So I would not anticipate the need for further review of that.
was it the runoff that you were particularly thinking about, John?
Yeah,
Okay.
yeah, I did, you know, just the distinction between, a pervious surface and an impervious one.
Okay,
Like,
you heard what Don said, right?
Yeah, I did. And
Okay.
you know, I'll defer to Don, his expertise.
So, Jack, would you be willing to revise your motion to include the revised site plan with the building
Yes,
dimensions and the setbacks?
yeah, that's fine,
So that's a motion.
yeah.
Is there a second?
Second.
Discussion? All those in favor? John?
Aye.
I did want to point out one thing, there is this requirement in the ordinance that, for inspection, for you. This happened the other day, sorry, I lost it, but you know about this, that you're supposed to inspect before they pour any foundation or footings?
We did it.
Okay. Just so you notify them.
Yeah.
You're supposed to notify them like 2 days ahead of time.
Make sure I pour it.
So they measure, so you can measure that where the buildings are supposed to be.
So, thank you very
Thank you.
much. And we will write up a written notice of decision, but you can put together and submit that plan, you know, as soon as possible.
Yeah. We'll have it all done. We can have it in.
Okay.
Thank you.
Thank you.
Have a good night.
Good night. So second agenda item is the Manitoba subdivision. A few things about that, just, I wasn't here, as you know, and I have some catching up to do, which I think I've done. But I was reminded of a few issues that I think, surround this application. One of them is process. And there are also some substantive issues that we might want to talk about a bit further, but the planning board had the initial discussion about this application on the 9th of April. There wasn't any vote with regard to completeness because it was determined that there were some items missing. And the applicant brought back a supplemental package with some of that information in it. We also, and that was dated the 26th of April. We also had a couple of letters and, Mark from Manitoba.
Right here.
I'm sorry, I don't dare to say your last name because I'll mispronounce it. So if you could tell me how to say it.
Benke.
Benke, okay. So Mr. Benke submitted, 2 letters with comments about the information that's been presented so far. The most recent one, responded to the supplemental package, and that was dated the 5th of May. So our primary purpose is to continue discussion about completeness of the application and whether or not we have all the pieces that are required and that we need to conduct a full review on this application. I don't know if we're there yet, but I think our conversation tonight will help us, determine if it's all there or if there's still some pieces that we need to receive. In terms of process, there was some discussion, I know, at the first meeting about the fact that this is a major subdivision, meaning it has a specific process attached to it that's laid out in the LUO. Begins with a sketch plan review and then moves to a preliminary plan review, which the board has to review and approve. And then a third step for major subdivisions is a final plan review and an approval. And the LUO lays out the various elements of those plan reviews and how to approach them. I think that we can assume that, at this point, although the sketch plan piece did not come in separately, all of the information that would have been required at that stage has been submitted and we've looked at it. So my assumption is that we are now in the preliminary plan phase of this review, and we're looking at the application, the preliminary plan application for completeness at this point. I would point out too that this process is rather sprawling. There are a number of different standards in the LUO that apply to major subdivisions, and those are the site review standards, the standards that are specifically relating to the preliminary plan review, and those are found in the subdivision site review section in sections J and K specifically. And the subdivision is also, or potentially is subject to certain performance standards in Article 8, having to do specifically with subdivisions. So all 4 of those pieces come together and are relevant in terms of standards that apply here. I would also mention that, our focus tonight is a continuation of a discussion regarding completeness of the application and whether we have all the pieces that are required. We have not yet gotten to the point where we've scheduled a public hearing. Presumably we will get to that point, but I want to remind everyone that our conversation tonight is mostly centered around the issue of completeness and whether or not what has been submitted is adequate, and if we have all the pieces that are required by the ordinance. So we won't be engaging in in-depth substantive discussion about the merits of the application and whether or not the information that's been submitted, it definitively complies with the standards or not. I mean, it's kind of a hazy line, but for the most part, we're going to be focusing on completeness issues and not compliance with the detailed standards, although we may need to get into that some of that conversation as we move into this. So I think there are 2 possible outcomes from tonight's discussion. One is that we talk about all of the information that's been provided, and make a determination that the application is complete, or we may identify issues that have not yet been satisfactorily addressed, in which case I think we would likely table and continue again in order to get the rest of that information in. But we'll see where the conversation takes us, but those are the two possible outcomes that I see from tonight's meeting. We will certainly, entertain questions or comments from interested parties who are here. But again, I would remind you that our focus is principally around completeness, and not on all of the substance of the standards themselves. So there were a number of changes and additions that were made to the application as a result of the earlier planning board discussion. And so I think it would be useful if you could begin by talking about some of those changes and the additional information that was provided in response to comments that were made. And then we can move into anything else that planning board members feel should be a subject of conversation.
Sure. Okay, fair. For the record, I'm Jane Howley, an engineer with Mainland Development Consultants. I'm here tonight representing Lovejoy Adventures. I also have with me here this evening, John Lawrence, with the representative of Lovejoy Adventures, and also Bob Berry of Mainland, who's what's your title now? He's the CEO of the company and a senior engineer. So a quick recap of the changes that we made based off of the planning board meeting on the 9th of April. Was we combined what was lot 2 and 3 into a single lot, which is now called lot 2. We saw no need to have such a long road extending out basically halfway through lot 2, so we reduced that length of road by approximately 465 linear feet. That reduction of proposed impervious and developed area then reduces the post-development phosphorus export such that it meets the phosphorus standard. So the export is lower than the project budget. So we no longer propose rain gardens for stormwater treatment of individual lots, although we are maintaining the stormwater buffer currently. We also changed the name of Birch Lane to Juniper Lane because we understood that there was a duplicate or another road called that in the town. We have the submittal or the additional submittal item here. I hope everyone has a copy, but just a quick recap of those. The planning board asked for a little bit more information on agent authorization, just to make sure that John is representative of his organization. We have a letter from his attorney in section 1 that goes over that. I spoke with the fire chief on April 25th. He didn't provide a letter, but I summarized our conversation in an email to him, and I provided that in this packet. Section 3, I provided the actual title of the document, a little bit more information on the preliminary soils investigation in section 3. Section 4 is a natural resources report by an environmental scientist of Mainland, outlining that there's no vernal pools on site. Section 6, got my numbers all backwards. Section 5 contains correspondence between Mr. Lawrence and the folks at Manitoba, just showing that there has been a dialogue initiated regarding maintenance of that first 400 feet of road. Because the road changed, I updated the stormwater management plan or the stormwater narrative to include the updated information. Section 7 contains a plan called building envelope and vegetation plan because the board asked for the vegetation or a landscaping plan. So I would hope that satisfies that requirement. Section 8 in the back of the application packet just has the updated plans. I think that's all I have for now, and hopefully I can help answer your questions. Or I guess I will actually note as well that I saw the first list of comments from Mr. Benke, which I'm working on drafting up some comment responses to currently. Just as a note, I haven't seen the second responses, but that's all I have.
I have a number of questions for you about the submittals. But before I go through my list, does anybody have any immediate questions?
I thought at the last meeting, Don, you raised an issue about having ATG 200 for the lot that's not part of the subdivision.
Didn't make my notes, was that?
Well, I did ask for information showing suitable soil on that lot, yes.
And I believe that, I'd have to take a look at it again, but I believe the new document in section 3, the soils, preliminary soils and application, I think has more information on it. And that's lot 9, now. So the lot that was already sold.
But we don't
Don,
have
what-
ATG 200 for any of them.
Correct, we don't have ATG.
And, Don, when I looked at this, let's see, in the ordinance, one of the requirements, which is on page 30, does say that, not only do we need to test pit data, but it says HHE 200s or equivalents shall be supplied with primary disposal site for each lot. And I don't see that we have those.
Correct. I did have some questions that I wanted to discuss about it. Typically in a subdivision, and of course, every town has their own standards that you have to run with. Typically in a subdivision of this size, the individual lot owners will develop their lot and obtain that form on their own. Because the HHC 200 form design is specific to the lot.
Yeah, yeah. Chip, what's your perspective on that?
I like the idea of the requirement to have those designs. This is a lot of setback, requirements in it from, proposed building site, from the, front and back. And I've had problems over the last few years with certain, neighbors that, had problems with septic tanks and leaching field problems. So I think it's a good idea. I know it's a little bit difficult, but most of the subdivisions that have just filled up that I've seen have had that and had pretty much specifically shown where the building pads or locations gonna be, give the, the purchasers an idea of what they're looking at and what they need to do. So again, drawn out, but I think it's a good idea.
I mean, my assumption was that it was probably there in part, because if we're talking about a subdivision, they're probably building envelope constraints, the number of different respects. And identifying that on the plan would do as Chip suggests, and not just leave it completely to the purchasers of each lot, but to outline, what the potential building envelopes are, which would involve the location of the septic field.
One of the problems I've run into is that I don't know if that's what happened here, but certain aggressive, builders that, buy lots, install their own septic systems and, drainage fields, and it's allowed. And that's where we run into problems with neighbors and everything. And so I find it a good idea to locate and have plans for the presentation.
And specifically what I was reacting to, if you want to look at the requirement that I was seeing, it's Article 6. Yeah, J46,
Or C6.
C6. Yeah, J4C6, that's right. Well, did you have questions or comment about that one, or should we move on?
I do just have one follow-up question on that. Form HHE 200 or its equivalent shall be supplied. Is there an equivalent to an HHE 200 form?
Really,
No, that's the design.
I think when this was written, there were things like holding tanks and other things, but that's been eliminated, so that's the go-to. And I can get you a copy of the most recent.
The next one I have is actually on the same page in that same section, which is, J for C7. And what I noticed in the package was that there was a statement about the adequacy of groundwater, for private wells. But this specifically requires that when water is to be supplied by private wells, evidence of adequate groundwater supply and quality shall be submitted in the form of a written statement from a hydrogeologist or a professional well driller familiar with the area. And I didn't see that we had either of those things unless I missed it.
May not be written exactly the same way, but in the original application with the green cover, there was a statement, I'm looking at Nicholas on this, we do provide a well data map. I don't know that we have a letter attesting to it from a certified geologist. It's notes. But the yields of the well range from 0.75 GPM to 30 GPM,
Yeah, I did see that.
but that's me and I'm not a certified geologist.
Yeah, and, you know, it says from a hydrogeologist or a professional well driller familiar with the area. So.
I don't know if we have one on staff and we could provide a letter attesting to that if that's needed.
Also in that same section, J for number 23 requires a construction schedule, including anticipated beginning and completion dates. And, you know, we certainly understand that construction is, you know, dependent when you get your approval and so forth. But I think we need some sort of a projected construction schedule. As part of the application, you know, that certainly could take into account that it's somewhat dependent on when, you know, when and if it's approved, but I think there needs to be something in that regard.
And that's exactly the case. The applicant would get approval before they get someone scheduled.
Yeah.
Although tentatively next summer is
Yeah.
possible, but I would
And
need something in writing.
Yeah, it can be an estimated projected schedule. I mean, it doesn't have to be definitive around the contract, but just something that gives us a sense of when you're hoping or expecting to start construction and how long a process it will be.
Okay.
Also in section J, number 27, this requires a narrative with respect to timber harvesting operations. And I didn't see anything about that in the application either. So this says a narrative describing any timber harvesting operation within the preceding 5 years, a copy of the forest operations notification and a written determination of the harvest compliance with the Maine Forest Service timber harvesting standards to substantially eliminate liquidation harvesting certified by a licensed forester.
Timber harvesting was complete in 2018, so that puts the completion of that about 6 years ago. Do you need just a description of?
So if it doesn't fall within that time frame, if you could make some statement about that for inclusion in the application.
That's easy enough.
I also noticed two, let's see. In section, Okay. Um, K3G. This one requires that the applicant shall provide an estimate of the net increase in taxable assessed valuation at the completion of the construction of the subdivision. And I didn't see that unless I missed it.
No, that's something we'll have to provide.
But Paul, just speaking as a lawyer, not, maybe there's a term of art there, construction of what exactly? Not the houses within the subdivision, or we're talking all the houses? Which of course may occur over a period of time.
Well, it says, where is it? G, an estimate of the net increase in taxable assessed value at the completion of the construction of the subdivision. So, I'm assuming it's an estimate, based on what the anticipated value of those properties might be.
But construction here meaning land clearing, what? Well,
I would assume, and I'm just assuming, I'm just reading what you are, but I'm assuming that that means the construction, the completion of construction of the subdivision would mean that the houses are in and they have a value, property has a value with a house on it, and what that estimate is.
And to read it the same, it implies that, I would agree that it's not super clear.
No, it isn't,
But
but it's there.
I think it implies that.
Yeah.
And from previous applications, that's what it implies.
And K, 3H, which is the end of that list. Engineer drawings showing the proposed name, location, and construction specs for all proposed public or private roads. So I know there's some information about the roads that's been provided, but I don't see that detail in the plan yet.
There is a road plan and profile, I believe it's, plan C 5.1, that shows, I can find that if you'd like me to. There's actually, multiple plans. One
Oh,
for
okay.
section.
All right. No, I missed that one. My apologies.
I have some question, I guess one of the abutters raised the issue about where the stormwater goes.
Mhm.
In that there's a lot that's not part of the subdivision that's owned by Mr. Lawrence where stormwater goes.
Mhm.
And how is that, how do you, Mr. Lawrence sells the property or decides to have a house there or whatever? How do we know that that property can still be used for stormwater runoff?
If I may, I think Mr. Morris.
Maybe I can offer some clarification. That lot is not buildable where the stormwater is going, so it will never have a house on it.
And typically when a stormwater, infrastructure is on a property, there's an easement set around it, so I would imagine that that would be typed up as part of some legal documents. I'm not a lawyer, so I'm speaking very limited, but there would probably be some restrictions on that lot too. If Mr. Lawrence ever were to sell that, there would be,
Right.
yeah, I don't know if that answers the question.
No, I think that there should be some easement or something,
Mhm.
because somebody might buy it and log it. Maybe the stormwater management part includes having a forested area. By the way, where are the wetlands on the first map? Where are the wetlands?
So the wetlands, it's a little hard, it's difficult to see from here, or from my engineer perspective, but they're all shown on the plan. It looks like little, like little patches of grass, and stuff like that.
How many acres are the wetlands?
Don't have the number of acres off the top of my head, but I could show buildable area on each lot shown in this kind of tan color. That doesn't mean that the whole lot will be built out like that, but that's basically area that's outside of a buffer, wetland.
What buffer did you use for the wetlands? To the buildable site?
I don't think I actually show any on that plan, but I do show a 75-foot setback on the street.
So you did the same for the wetlands, 75 feet from the wetlands?
So if that's a setback on the wetlands, I must have missed it.
It depends on the acreage of the wetlands.
I would have to double check the area of it. I don't know that off the top of my head.
I had another question on stormwater as well. You know, and it is just a question. It's not a firm opinion at this point, but as I look at this, I did spend a little more time refreshing my own memory on, you know, DEP stormwater law and rules and the definitions and it raised the question in my mind about whether or not a permit by rule for stormwater is sufficient and appropriate in this case, given, you know, the definitions of developed and disturbed area, and whether or not the assumptions that are made in the application are sufficient to simply trigger a PBR rather than a full stormwater permit. So it's a question to you, I guess. It didn't seem like much that was included in the assumptions. It was, you know, a very small.
Certainly,
Threshold.
that's a good question. So this is a 9-lot subdivision. So for DEP permitting thresholds, only the common infrastructure is counted towards permitting thresholds. And so currently we're at 0.68 acres of new impervious area and 1.3 acres of new non-impervious developed area. And so DEP chapter 500 has a helpful flow chart. And when I follow the flow chart, 1 acre more of impervious area or 5 acres more developed area, and any other watershed being a lake not most at risk for development. We don't check that box and we land solidly in a stormwater permit by rule.
Don, I don't know if you've got a perspective on this as well, but you know, when I read this, I guess I didn't limit the disturbed area just on the infrastructure. I mean, when you look at the subdivision as a whole, there's a lot more potentially disturbed area within the subdivision for, you know, on the building lots themselves. And particularly since the definition of disturbed area is anything that doesn't revert to its original condition. All of that would need to be included, and it just struck me that for a subdivision of this size, it seemed very likely that would be more than 5 acres in an area this large.
It may, because I'm not dictating how much area the lot, the owner of the lot build out, but for DEP permitting thresholds, that's how they look at it for subdivisions 14 lot or fewer.
Is it? Okay.
Lot 15 lot subdivisions are automatically slowed up, in which case we do include the estimated build out area of each lot for the DEP threshold. And I should also note that I did make reasonable assumptions as to new developed area on each lot for the purpose of stormwater quantity calculations.
Mhm.
And for phosphorus calculations, so we had to calculate that export.
Okay, so that was the sole purpose of the assumptions that you made for the individual lots, was for stormwater and phosphorus.
Correct, yeah.
I think when you were here last time, we asked you whether, somebody asked you, I think, whether the site location law applies. And I think you said no.
It is not, it's just a stormwater,
Why is that?
because it's 14 lots or less, and we don't trigger the site law proposed areas.
So, let's look, I'm not familiar with the law, but, so it's a subdivision of I thought it was 5 or more lots,
You're dating it, but
as stated. But I was,
they changed that quite a while ago.
yeah, I looked online too, but it's, the statute, it doesn't seem to be changed. Maybe, I don't know. So it's 15 lots.
Yeah, you said 14.
14 and under, that's why there's a lot of 14 lot subdivisions in the state of Maine. Going 15 or more, if I understand correctly, is automatically slowed down. And we do plan to submit a stormwater permit rule as well, and if there's any comment or questions by DEP, we'd be happy to forward those on to you folks.
Yeah, I was gonna ask about, you had identified 2 PBRs, stormwater and NERPA,
Yes,
and you've not received anything back on either of those yet?
I have submitted the NERPA application for the NERPA PBR. I was holding off on the stormwater PBR, just because there was a question about potential changes, and so I didn't want to go back to DEP. But I will have that submitted, sometime before final review.
And we would ask that, you know, when you do get responses back, if you could provide those to Chip, that would be.
I would be happy to, however, stormwater permit rules are one of those, odd.
Oh, it just happens.
It just
unless-
happened.
Yeah,
So it's 2 week review time if you don't get anything about it.
and so in that case, it would be helpful to get the application that you submitted, and then we'll know what was approved. Chip?
I know I don't have to tell you and the board, you do have the right to ask for an outside consultant to answer a lot of these questions. My hesitancy with a PBR in this case is I'm very much aware the DEP is very short-staffed, they're very overburdened. In another town I work for, they've been waiting over 200 days for a response for a regular DEP study. And to use a PBR, which if they don't get back to you in 3 days is assumed okay. I think it's walking a tight line. It might be legal, but I'm not real comfortable with PBR in this instance, knowing some of the testimony that you're probably gonna hear when we get to a public hearing and some of the questions I've been fielding. So it's something you might want to consider.
And what are you suggesting, Chip? I'm not.
Well, I seem to be hearing a lot of questions about wetlands, about drainage, phosphorus, where the water's going and everything. You may want to consider a naturalist or a wildlife person or somebody to come in and do a study with a lot of your concerns. I'm just not real comfortable with the PBR for something of this magnitude. Again, maybe it's legal, but
Well, the PBR that he's talking about has to do with stormwater
understood.
only.
If I may, I saw a hand in the back, if I can interrupt, did you have a comment on?
Yeah, just a comment that, the DEP, they are understaffed and they're way out. Believe me, I know. I've been working with them for a long time. They have a separate staff that handle PBRs, and we know they're looking at them because we have gotten comments on other stormwater PBRs that we've done for other projects. So just because they're behind on larger applications, that's actually a different group. They are on time with the PBRs. I just want to mention that. That's a 14-day, not a 3-day. They've got 14 days.
And one more question on that point. When you submit, I don't know what the PBR application looks like for stormwater, but when you submit that to DEP, you would submit your subdivision plan as part of that. So they would have the opportunity to look at the plan you're putting forward, and they would pass their own judgment on whether or not a PBR was a good fit. Is that correct?
Correct, the plans are scalable, we don't provide CAD files or, too many electronic files, I mean, we plans, PDFs, but they are scalable. DEP can do their own estimates and gut check our numbers. If I'm saying 0.6 acres and it really looks more like 5, they should be able to pick up.
And the other thing I noticed in here, this is my last point.
That's okay.
is that, you had submitted a number of, request letters to review agencies, natural areas, fish and wildlife, historic preservation. Have you received anything back from any of those yet?
I have received two, and they didn't make it into the most recent submittal, but MHPC and I want to say it's Inland Fisheries and Wildlife, but I can provide
Okay,
those.
so if you could provide those, that would be helpful. And the third one, whenever it comes. Okay, others? Questions? Yeah.
I'm just scanning again.
Go ahead.
So you had the correspondence with the fire chief, but there has not been any response from him to date.
The fire chief has not typed up his own letter, but I typed up a follow-up email summarizing a conversation.
And he wanted a fire pond, right?
He did make the comment that there's not too many fire ponds or hydrants in that area. So we did make that recommendation, and I figured that's something the board would want to discuss.
Yeah.
Because there's other options as well to a pond, not that we're completely opposed to it, but what's it called, impact fee is also an option that some towns use. And what that would be is the applicant pays, let's say $15,000 or $20,000 as a fee, that goes into a fund with the town, and stop me if I'm telling you. And then the town can use that money to build a pond that better benefits the area and not just that subdivision. Perhaps a pond would be better located somewhere else. Just as a note.
Are you expecting the letter from the fire chief?
I would think not. Or he hasn't received one, and I talked to him a while ago. Does it?
I saw your summary of the conversation, and it was like for him to, he could deny it or affirm it, or,
Yeah.
He didn't respond to it.
yeah. Where would you put a fire pond?
Probably, if we were to do it, probably somewhere on lot 2 down here, because the road generally drains this way, we would be able to capture that flow, keep the pond full of water, because it needs whatever the volume is typically. We can extra water goes to it, but yeah, generally lot 2.
Would that change what you're doing with stormwater management, if you have a fire pond there?
If we had a pond there, we probably wouldn't use the buffer. You can double, a fire pond to be used for stormwater treatment and management. We can kind of kill two birds with one stone, so to speak.
Would that solve a lot of problems?
It could potentially. Well, it would remove a buffer off of the adjacent lot that Mr. Lawrence owns. And put most, if not all, of the drainage infrastructure or stormwater treatment on lot 2. There might still need to be a buffer downstream somewhere, or a level spreader at least, potentially, to spread out the spillover if there was an emergency, not an emergency, or the emergency spillover. Well, I don't know.
Other questions? No.
Request,
What's that?
a request. There was a discussion about, you were trying to figure out how much acreage of wetlands will be in this project. I'd request, if it's okay with the board, that we know if they're contiguous wetlands, because that's what sparks the 75-foot setback. If there's 10 acres or more of contiguous wetlands, so if we could get that number, that would be helpful.
Yeah, and Jack had raised that question about wetland setbacks, and I think that is important. We need to have those wetlands characterized, so we know if there is a setback requirement, what that buffer is.
I can review that. And most of it actually is contiguous, although again, I don't know the other area, I don't know, but most of it is together.
Other issues? Peter, Brandon? And then,
No, I think there's pieces missing still.
Dawn,
Getting there.
anything else? I would encourage, as I mentioned, there are several different sections in the ordinance that have requirements and standards that relate to major subdivisions. So it is, kind of a sprawling, regulatory structure in here, several different pieces. And I would encourage you, I think, to go back and just re-review those to make sure that nothing's missing. And I think, I tried to go through fairly carefully and identify what I could see. But I think it would be a good idea for you to do it also and just make sure that we're not missing anything else. So in addition to those things we specifically talked about tonight.
Something from last time. This particular project also has this unique situation of the road, right? And I'm just wondering if there was any update on the communications with respect to that. I saw that, I think there's a letter that Mr. Lawrence had submitted, but didn't see any response to the letter necessarily, so.
It's still a project in the works.
Okay.
If I understand correctly, the applicant's attorney is wrapping up some verbiage.
Okay, so I'm just making sure that it's a bit unique in this situation compared to us.
Still very much on the radar.
Okay.
So if there's no other questions right now from planning board members, Mr. Benke or any other interested parties, did you have specific comments or questions about completeness of the application that you'd like to put forward at this point?
Not at this point.
No? Anyone else? Anyone in the Zoom space? With specific comments or questions? Okay, hearing none. Okay, so I think there is a list at this point of things that we would like additional information on or things that haven't been submitted. And if you could just let Chip know when you have that together, and we can talk about when we'll resume this conversation and get it on another agenda. But, that depends obviously on your schedule and how you're able to pull this together. So talk to Chip about that and we'll proceed accordingly.
On the question of schedule, there was in the agenda that had a date for the next board.
Yeah, and it's incorrect. Yeah, it should be the 28th, not the 21st. Yeah.
Is there something about when we reach this stage that the CEO is supposed to notify butters?
Well,
There's something
that's at the point where we find it complete.
in chapter next. I thought it was down the description.
I don't think so. No. The the preliminary plan. That's where it talks about, after the determination on the preliminary plan is made, it kind of reverts to the regular process. We schedule a public hearing and abutters will need to be notified about one. But the sketch plan is kind of an informal piece in this process. There really isn't a decision that comes out of it, and it's just general information. So we don't really get there until the preliminary plan. Okay, did you have any questions for us before we wrap up?
I have none, but I'll get that pulled together as soon as I can. I'm gonna be out of state for a few weeks doing some Army training, so I'll be kind of out of the loop. But we'll be in touch, Chip, about the next planning meeting. That's all. Well, thank
Thank
you
you
all.
very much. We appreciate your time.
I appreciate your time as well.
Don, I did see it 15. I did see it's 15 lots.
Yeah, that mentioned quite a long time ago. It's in, no, my takeaway on that was, so, just that anything less than that, it's gonna be a problem. All towns have subdivision required. At the time, it seemed like it was overlooked.
Define the subdivision, 5 or more lots.
Yes.
If it's, residential, so it's 15
Okay, we have a pile of minutes to approve. Since you guys didn't do any models.
So the marijuana.
No, I'll,
Whatever.
I'll update you on marijuana before we do minutes. So a question, the initial question that came up about the marijuana retail outlet application, medical marijuana, medical caregiver retail store, was that it was unclear who was on first, the state or the town, in terms of issuing an approval. So I had this long convoluted conversation with the Office of Cannabis Policy. And they told me that it was the town first, not the state, but there were varying opinions on that. And I can tell you, after spending a bunch of time with it, the state rules and statutes, they're just mind-boggling. It's unbelievable trying to untangle all of that. So I had a couple of conversations with the Office of Cannabis Policy, and it raised more questions in my mind. And ultimately, I had a conversation with the town attorney. And the limiting factor, in her opinion, and I agree with her after looking at all this stuff again, is that what, I forget the guy's name, Mr.
Ready,
Okay.
I think tell you that, so.
Well, what he applied for was a dispensary,
Medical dispensary.
medical dispensary,
Medical marijuana dispensary.
yeah. And
Not a caregiver.
And if you look at the town's marijuana policy, the marijuana establishment policy, there's a list of those things that the town has opted in for.
Yeah.
And it does not include dispensaries. It does specifically include medical, caregiver, retail stores. And that's what the other was approved as, the happy camper and so forth. That's what we did with that.
Never do.
So it was determined that we could not go forward with the dispensary application because the town has not specifically opted in for dispensaries. So I had a conversation with his attorney and said that, you know, I couldn't make any guarantees, but we could consider if you wanted to come back with an application for that instead, for the caregiver, the medical caregiver retail store, instead of a dispensary. So the ball's in their court.
What's the difference between the two?
Well, it's complicated because it's all, the definitions are state definitions. And I know that it has something to do possibly with the amount of product that they can store and keep on site. Dispensaries have the ability to deal on a wholesale level. There are some other things, other benefits, I guess, that come with being a dispensary that, you know, the smaller caregiver store would not have.
I see, so the caregivers, in general terms, you believe the caregiver store is a smaller operation.
It's more limited in
Little
its
more
scope,
limited.
yeah. Yeah, and I don't know all the ways because I couldn't spend any more time with the state stuff. It was making me insane, but those are some of the differences.
So we can review it for what he proposed.
That's correct.
So he's going to potentially revise it.
Well, I'm not sure what he's going to do,
So
exactly.
he withdrew his application.
I don't think he's withdrawn.
Well,
The conversation,
To be determined.
TBD, exactly.
you know, the ball's.
He's not here
in
tonight.
their- The ball's in their
Right.
court.
Although it's not relevant strictly legally speaking, you probably all read that Mr. Beretti had a problem with it, in getting approval, apparently.
Say that again.
Mr. Beretti had a permit application in Augusta, which according to the County Journal has been denied.
Yeah.
I'd hesitate on talking about that.
No, I wouldn't talk, I have no.
Yeah, I'm just saying he's been using it in a court case. There's, I think, Eric was a little bit irritated that this letter went out to everybody. It's hearsay. And it's not something that should be.
And, well, I mean, what,
Well, what the city did isn't you're saying.
yeah, and it was reported, there was something in the KJ, and just so that, you know, everybody has the same
Whether the
information.
city was correct, if the city because it was correct, I have no idea.
There was a letter that was sent, it's not signed, it's an anonymous letter, but it was sent to Eric, to me, to you, and
That's
somebody.
just a copy of the KJ letter to the editor.
And so, you know, it outlines this whole thing about what went on in Augusta, but it was sent to us specifically here in Readfield.
And it's because it's the same potential
The same
application.
applicant, potentially, yeah, yeah. And again, just so that you know that that's circulating.
That answers why he's not here. They're not here.
So if, you know, if you or I do not hear anything from them, I think we do need to ask them, well, we need to ask them to wdraw it anyway.
I'll be
because we
making a
can't
phone call
proceed.
tomorrow. I was not aware that they were not gonna be showing up. And so I'll give a call tomorrow.
Yeah, well, I told you that I had that
Yeah,
conversation.
I know you had a conversation, but again, it's kind of like, as you said, TBD, it's in limbo, whatever. But I think your conversation merited a letter, an email, or some kind of response back saying that it was being withdrawn, or we are considering moving ahead. We didn't get.
Under any circumstance, the application that they submitted needs to be withdrawn.
Yep.
Because we can't do anything with it.
He purchased that property, right?
Yep.
That's what I'm hearing.
We should buy.
We could go in on it together, Jack.
Great location.
It is a great location.
The Jack and Henry candidates show.
The convenience store did good business when it was.
There was a good little store there for.
Yeah, it was.
Many iterations
Yeah.
over the decades.
All right, we have 4 sets of minutes, the first of which is from March 12th. I saw I think in the minutes, Peter, that you had provided some comments on one set. Was it this one? Is that
Mark
right?
12, yes.
Okay.
And they were, so, right, if you want to know what they were, I made the notes from. They were very minor.
I don't, everybody else heard them. I don't know, you don't need to go through them
Good.
for me. I'm sure they were.
Yes, I remember those.
Okay. I don't know if you captured this. I had two minor comments, and you can tell me if you already addressed them, but there's a 1-line paragraph about 2/3 of the way down on the first page, representation for Frank, however you say his last name.
Lenny.
Right. Then we changed the second sentence.
Okay, I had a change to the first sentence, and I would suggest saying that Frank Bereni did not attend, nor was he represented at the meeting. Rather than saying representation did not attend. And then, in the last paragraph, the middle sentence halfway on the first page. The board discussed ways to limit a potential influx of transient renters in Article 8, etc. I would suggest saying a potential influx of transient renters given the provisions of Article 8.
That's been transient renters and articles.
And then on the next line on the second page, it says Jamel had suggested the use of the term owner occupancy as a requirement. I would just reword that slightly to say Jamel had suggested the use of an owner occupancy requirement. So scratch the term and as a. Okay. That's all I have there. Anybody else on that stuff? March 19th,
Do we vote on each of these separately or?
we'll just vote as a package.
Okay.
Well, it'd be easier though if we're amending certain ones.
Well, that we weren't all at the same meetings at all meetings, so
Yeah.
it's very difficult.
Yeah.
Okay, whatever you want to do.
So then, I mean, to approve the March 12th, 2024 minutes as amended.
Second.
Discussion, all those in favor? Don?
Aye.
Okay,
Aye.
March 18th. And Jack, no, it wasn't this one. So I didn't see any edits to March 19th, yet, okay. I had a couple of things on these, the second bullet under public hearing, where it says the dwelling unit density bonus. That whole concept is really kind of complicated, and I found it was difficult to capture in these little bullets in the minutes, so I'd suggest, probably simplifying it a bit, that one in particular, to say, density unit, dwelling unit density bonus. Qualifies for, if they get rid of how many people can afford based on the median income in town.
Okay.
And get rid of if. And then say, so we're talking about the density bonus there. Qualify for scratch affordable housing would allow. So it would say qualify for 2.5 times the normal number of units on a parcel if determined to be affordable housing, in quotes, based on the new definition in the LUL. And then eliminate income levels have to be maintained to remain qualified. Because all of that information is in it. And then, the first line under the, after opening the public hearing, Marty Hamish, to elaborate on what qualifies, insert as affordable housing. And, scratch definition for the period after affordable housing. In the second paragraph in the public hearing, so in the middle of the second paragraph that begins affordable housing, I would insert the location of affordable housing does depend on the standards of different zones and districts in the table of uses in the other law. And I would eliminate some areas could trigger. And start that next sentence by saying subdivision requirements could also be triggered in some cases. And eliminate which would have another set of requirements. The subdivision requirements could also be triggered in some cases.
And then I can get rid of which would have and what is the requirements. Right.
Yes.
Perfect.
We're gonna pull with that paragraph some more. Maybe the last sentence, the second to last sentence. Perhaps you should say Carol reported. That she was pleased that the select board turned down the collaborative grant. She did say that. But it wasn't just.
Is it material though? I mean, I was gonna actually make the suggestion that you have to sort of. We have to sort of expand that a little bit, because it sounds like so out of context when you read the paragraph.
I thought that
What grant?
I thought that the final sentence below, right after that, probably was unnecessary. Even, it just sounds like we're patting ourselves on the back, and that she was happy with our work. I don't know if she said that.
She did, but I could get rid of the last two sentences if you guys think talking about it.
She thought it was relevant to this conversation. But I would understand why reading it would not be obvious.
Right.
So,
What she said, as I recall, which I didn't take notes about, was that, we don't want to be stuck with someone else's solution. Right, some other towns could outvote us and what they, and we should have a Readfield only solution to the issue.
so Peter, you.
Sorry, I wasn't there.
The video is that one.
I wasn't there, I can't comment. Context, wasn't able to hear
I thought it was an odd, personally speaking, I thought it was an odd statement she made, that she was happy that we turned down the grant, but.
Yeah.
Well, whatever.
it. I'd recommend just deleting the last two sentences, because I don't think they're material. So, because I think it's confusing.
I'm,
There we go.
yeah, I'm ambivalent. I can go either way on. You have an opinion, Brandon?
I don't think they're relevant.
Okay, all right. Done, get rid of it.
Use it for the easier for action.
It is confusing. I mean, it would cause people to say, what?
Yeah.
What is this?
Yeah, I think that-
Hold on just a second. This is a little thing, but, the last sentence, it says planning board and North Star consultation, consulting instead of consultation.
There was a word that
Oh,
was-
really?
Yeah. Get rid of that one, right? That's that last one.
Oh, that's right, yeah, okay. And then on the other side, on the second, page. On. Third line down, it says, well, there is not time currently to make those changes. I think it was more that there was not time currently to fully consider those changes. We could have made them, but they would have been ill considered.
Wasn't there consensus?
And the last sentence, I think it might be helpful to say municipalities are authorized by statute to regulate short-term rentals. That's all. Yes.
I'll make a motion to approve the minutes of March 19, 2024 as amended.
For a second,
I'll second.
discussion, All those in favor?
Aye.
John,
Abstain.
one abstention.
Sadly, not me.
Okay, on April 9th, Jack made a number of edits to these. I've got a couple of additional ones. What? Yeah, we did this.
Okay.
Spreadsheet.
I actually already applied them.
Yeah, you did.
That I have.
Yeah.
So.
Yeah. And I just had a couple of additional ones. The last paragraph headed North Wayne Road, Manitoba Camp, Ground Road. Shane Howley of Mainland Housing Development, it's just Mainland Development. And on the second page, the first full paragraph, the third line from the bottom. It says, subject to an ERPA, that's NRPA.
Okay.
And instead of environmental resource, it's natural resource. And then at the tail end of that sentence, it says, and DEP stormwater permit by removal, it should be permit by rule. That's all I've got there.
Anyway, this is really big. Actually, the name of Mr. Howley's company is spelled, it's Main, MAIN-LAND.
Okay.
Development Consultants is their full name.
Anybody else? April 9th.
I make a motion to approve meeting, April 9th as amended.
Is there a second?
Second.
Discussion. All those in favor?
Aye.
Okay, last set from last meeting, April 23rd. I have nothing. Anybody have any edits?
You really had a forum at that meeting.
I'll make a motion to approve the minutes of April 23rd.
Is there a second?
If somebody was there.
4 options.
Peter?
I have to abstain, I wasn't here.
Don?
Okay, Brandon seconded. Discussion? All those in favor?
Aye.
Okay, so,
Abstain.
Jack, Don, Brandon, and John,
Don.
Peter, me, and Henry are abstentions.
They did a pretty good job with that, solar application, I thought. That was okay.
Yeah.
They were pretty sensitive to lots of things.
Yeah, they were. I would actually, I was gonna, I'm glad you mentioned that. I was gonna ask, I had, edited the final notice of decision on that, and it's been signed and sent out, but if any of you would like to have it,
So, sure, I'd like
you
to
can
see.
send it around to everyone.
Yeah,
Okay.
great.
You didn't
And
go
you
on
can, you can do that.
I actually did go up there and look at it. It is actually gorgeous.
Good job.
I didn't realize that building was so.
Make it
big.
up.
Okay, gotcha.
I did not.
Tips and septic.
Septic, it was a septic spray.
We had people taking pictures off at the meeting after.
Yeah.
I didn't go.
Yeah, poor Kara was sitting up at the podium. She's picking tips off her arm and setting them up.
Well, I got two. Shut. I have a suggestion, question, something to hold out there. The next meeting is the 28th. I have nothing firm for that meeting. That is the meeting that follows the long Memorial Day weekend.
Yeah.
So I don't think many of you want to be reviewing material, seeing as there's nothing on, you might want to consider taking that pass at the next meeting.
I rather doubt that all the material is gonna be in time for everybody to look at it from the Toma by then. Yeah, he did say he's going away. but- So, what's your pleasure? Shall we move to the first meeting in June?
That's fine, with me. Just to let you know, if it's Tuesday, June 4th. I have to go to.
Second Tuesday. no,
Oh, the
first.
second Tuesday.
Yeah.
Okay.
That's graduation day, I think.
Right, that's the problem. That was the problem I was gonna put out.
The 11th,
Is everybody gonna work out?
That's election.
that's not a good day.
Oh, that is
a
a
day, I won't be able to do that one.
Yeah, that's gonna be
That'd
that's gonna be a problem.
Maybe the 10th, we do the 10th. Or is it confirmed?
Or would it be better the day after on Wednesday?
You talking about the June meeting?
Yeah. Or maybe we reserve judgment for now and see what's queued up.
Mhm.
And then pick a date based on that.
That's what I would do. You may only need one meeting in June.
Wouldn't that be enough?
I have a question when you're playing. I had somebody ask me this question, and I thought I knew the answer, but then, so apparently, and I went and checked, and it's true. So they were looking for public notices for when we publish public notices, and they went to the KJ and they typed in, they have a public notice page, and they typed in Readfield, because you can search by your community you're in, and it was blank. There are no public notices being published in the KJ, is that?
No, they've all been published, and I have records for all.
So they're not showing up though in the database on the KJ,
They're
and
not.
and so they told me this, and I said, well, that's
You
impossible.
can send copies if it wants them,
But
but
then I went and looked myself, and I'm just letting you know that the KJs, I don't know if we pay them to publish it, they're
yeah,
not
it's
available.
over $200, yeah.
People can't find them, there's blank,
Yeah.
so like, you know.
Well, is what they're calling, are they legal notices? Or, I mean, is there a distinction between a public notice and a legal notice?
Yeah, they have I think there is, but they have a page that, you don't have to have a subscription or anything, because it's public.
Yeah,
Oh, this is the online?
It's online, but that's how people find it these days, 90%.
I understand that. Yeah, I'll give them a call, find.
I was just asking. Somebody asked me this question.
They're in disarray right now. They're in the third
I
owner.
didn't know people even looked at those things anymore, but I guess they did.
They're on their third owner. I've had difficulty, getting things done. Takes multiple calls, but they are being published in the paper version. As to the online version, I'll give them a call, find out what's going on.
Yeah. Okay.
Yes, take rebate.
I doubt it.
okay, anything else, anybody? Not, we are adjourned. Thanks.
To a date to be named, is that?
What that?
You're in until a date to be named later. How would
Let's
that
see, it will look like the sunny guy.
Evening, everybody.
Night, John.
All right.
I acquired it and take it,